Welcome to the I Got Fired podcast, a podcast for people who've been fired or afraid they might be. I am Tom Spiggle, founder of the Spiggle Law Firm and host of the podcast. Today, we're going to be revisiting a topic that we discussed before on this podcast, and that is the subject of a demand letter and the different ways you can deploy that. Before we get into that, some legalese. This is intended to be for educational purposes only. It's not to form a legal relationship with our firm or to be specific legal advice for you. If you need specific legal advice, you got it. You should go see a lawyer. So now let's talk about demand letters, and in particular, something that we are using now at the firm called a discovery letter. So what's the difference? A demand letter is the classic starting salvo in a personal injury or an employment kind of legal action where your lawyer will send a letter to your company or former company, setting forth the things that you allege were done wrong. And in a demand letter, as it sounds, at the end of the letter, there'll be some kind of demand, we're requesting a year's worth of pay, benefits for a year, whatever, the bells and whistles might be. There's a demand included in it. And these are very common, and there's nothing wrong with sending these letters. Usually, certainly management side lawyers are used to dealing with these. They know how to handle them. It's sort of like a dance that you engage with, at least your lawyer does, with the other side, and everybody knows the steps, right? So you've taken the first step. Now defense counsel is going to take their steps. One wrinkle on this that we are using now is, again, something called a discovery letter, which is similar in that it is the opening contact with your employer or former employer, and it'll set forth the facts, what went wrong, what laws that we believe were broken. But rather than it having a demand at the end, it is simply an invitation for the employer to respond and share what it may know or thinks it may know about this situation. The advantage to this are twofold. First, the way that we use it in the firm with the discovery letters is they're much shorter. I certainly understand the impulse when you come hire a lawyer that you're rightfully upset. You want to go after them tooth and nail, and it feels good to have a 10-page single space letter with attachments that you can really just hit your former employer with. And there's a time and a place for those kinds of letters. The problem with them is that sometimes they don't get you any better result than a short 3-page letter that sets out the highlights with what went wrong. And the reason for that is there are any number of ways, as we discussed in the previous podcast, that employers may respond to this. They may not respond at all. I was dealing with a client that had a letter sent, not by my firm, but by someone else, by this sent to his former employer, which was a big company. And this was a great letter. It was well written. It set forth the law. It was as good a demand letter as you could ask for. And it produced, and it was expensive, right? He was paying for this, and it was an expensive letter to produce. And it got actually, zero results. The employer just didn't respond to it. And that's not uncommon. There's no requirement that an employer respond. There can be any number of reasons why it won't respond, at least initially. But the point is, he could have gotten the same result with a short 3-page discovery letter. He would have discovered that his employer's initial move was not to respond at all. The benefit also is that if it slightly changes the dance steps, rather than saying to the employer, like, hey, we know exactly what went wrong, we're making this demand. No employer is going to roll over in the first instance and pay what you ask for. And it can, in certain circumstances, drive the employer into a corner, and they, rather than, reach an agreement with you, they're so angered by the letter that it puts them in a fighting posture and a settlement posture. I had a case, this is early in my career, when I didn't know better. And we were sending a letter to this client's former employer, and he wanted to put a big number on it. Um, and while one could certainly make an argument for why we might be entitled to the number that he wanted, it was very high and probably more than he could certainly expect if he'd gone all the way to trial and won. And the response I got back from much more seasoned opposing counsel was, um, "Hey, get back to me when you guys are ready to be reasonable." I mean, he didn't even have a counter offer. He indicated he'd be willing to make one, but he wasn't going to respond to what was really, in some respects, sort of an outrageous demand. So here's an instance where, you know, and so what we had to do is we had to follow up with another letter where we're automatically bidding against ourselves and lowering the demand, which is what we should have done in the first place. So with a discovery letter, you get rid of that risk, right? I mean, you are coming to the employer and saying, "Hey, this is what we think went on. If you have a different side to it, or if there are things you want to share with us, hey, we're willing to listen." And you tend to get a better response from the employer that way. I had a case again some years ago where we sent a letter like this, and the opposing counsel, who was very experienced, wrote us back and said, "Hey, I bat demand letters down, weekly, but I was impressed by yours and the stance that you took. And if you'd like, come down to the company, and you can go through the files that I have, and I'll show you why I think you don't have a claim." And we did that, and he turned out to be right. I mean, they just had some things in their files that would have made it very difficult for us to win the case. And our client just didn't know that these factors were there and this documentation was there. And so it saved her a bunch of time and heartache. We were able to explain to her that although there had been, she'd been treated badly by this company, the legal claims that she thought she had were going to be very difficult given what the company had disclosed. And she was able to go on with her life rather than wasting weeks and weeks, potentially months, of going back and forth and getting to, maybe filing something and getting it dismissed. So that can be another benefit. The first benefit being that it's short and you're not pulling out all the stops for a demand letter, and thus it's cheaper and you can get it out more quickly. And then second, you are more likely to get some sort of response from the employer. And then then it doesn't stop you from coming back with a demand after that. If the employer responds and they don't have any good response to it, or the response that they have is, sometimes this happens from the employer's side, right? The response they have is laughable. Well, then you know that you're on to something. There's nothing hiding in a file there. They don't have something on videotape. They don't have some kind of rabbit they're going to pull out of the hat that's going to affect your case, potentially end your case. And so now we have a better idea that we don't face one of those landmines, and then you can be in a better position to charge full steam ahead. So that is what we call a discovery letter. It is a variation on the demand letter in that we take the demand out. So whether you're working with us or you're working with another law firm, it's something to consider. I mean, talk to your lawyer about, how you want to approach the company. Is it worth, putting everything in the kitchen sink in a demand letter? That means it's going to take longer, it's going to cost more, and the response that you're going to get is uncertain. Now, if that's what you want, you want to you want to go through the banker's boxes of documents. You want your attorney to attach, make all the attachments. You want to put a really strong foot forward. There certainly can be good tactical reasons to do that, but you need to do it eyes wide open, and you need to have a tactic behind it, which could be like, "Hey, I want to, I don't want to hide the ball of these guys. I want to come out and show them what I got because I think this is going to make them come to the table." Speaking to you as the employee or somebody's working with the attorney, just make sure that you listen to your attorney's counsel on this. What you might think is a really strong demand letter that's certainly going to get a response. Your attorney may think differently, not that you don't have a case, but that, this 10-page demand letter you want to send may not get the result that you want. Maybe it's because your attorney has experience with this employer and knows that the first salvo that you're going to send out, they're going to ignore, or you're going to get some, some sort of kind of canned response to. So, sending some, really pimped out, some letter with a lot of teeth to it may not be a tactical advantage. I have had cases where, we have done that for tactical reasons, and there were good reasons to have all the attachments and to come forward and make a really strong presentation. But for most cases, you're going to get the same initial response by a short discovery letter as you will by a really long demand letter with attachments and a big demand at the end. So just keep that in mind as a possibility. The discovery letter sometimes can be, for many cases, the best way to start. They take less time to produce, they're less expensive to produce, and you tend to get, if you're going to get a response from the employer, it's not one that immediately pushes them into a fighting corner, because you invited them to share, invited the company to share what it knows. And it's a way, and a final benefit, it's a way to get some early discovery, because you don't often know what the company has. They hold a lot of the cards. They've got, all the databases. They've got the employment file. And in some states, there's no requirement that your employer give this file to you. You don't know what's in there. And so it's in your interest to get some initial discovery, have them put some cards on the table, so kind of what your next move might be like. So that's a suggestion. Rather than go, every time reflexively with a demand letter, consider or talk with your attorney about a discovery letter, or whether or not that's the appropriate approach. It just can be another tool available to you as you pursue your claim. I hope that's helpful. If you'd like some more information about employment law and about how to keep your career on an upward trajectory, you can check out the careerrocket.io, and you can get on our email list. We'll give you an email weekly with the latest and greatest in employment law and other tips and tricks on how to put your career on a strong foot forward. Also helps if you leave us a review on whatever podcast platform you're listening to this on. In the meantime, good luck out there.